Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hi there, I'm Andrew Struve. I'm a trial lawyer here in Southern California for more time than I'd like to admit. And thank you for joining today. I appreciate it very much. Subject matter for today is zany, wacky, and just plain hilarious lawsuits and opinions. But there actually is a point to this. And we're going to talk about some of the things that go on and how these opinions were written. And some of it will be entertaining and some of it may be thought-provoking. I know from prior experience that in our audience are some practicing judges, some retired judges, and also quite a few staff attorneys and clerks and judicial personnel. So you may get a particular benefit out of some of this, and I think there'll be a little bit of something to take away for everybody. It's what we try to do. So I do want to start with an icebreaker just to give you an example of what we're working with here. I'm not going to give you the case names and citations. They'll appear in the written materials. I will give credit where it's due, and here it's due to the Court of Appeals of Michigan, coming to you today on a motion to dismiss. And here is the opinion from that motion to dismiss. It reads in its entirety: the appellant has attempted to distinguish the factual situation in this case from Renfro v. Higgins Rack Coating and Manufacturing Company, Inc. citation. He didn't, we couldn't, affirmed. End quote. Well, there you go. Pretty clear what the court thought of the fact that it was bound by existing precedent. You know, perhaps one could have given a little more factual explanation, but this is what the court did, and there you have it. I don't think there was a lot of ambiguity in the decision. In terms of the guidelines for judicial opinions, every jurisdiction has its own. They also have their own style. It really depends on the cohesiveness of the bench in a particular court. You will notice some repeat players among the courts that we'll touch on today. Some of them seem to have a funnier bunch or had at the time the opinions were written, of judges and justices than others of them. But for reference, for purposes of judicial conduct, which I think is very important to focus on here, I'm just going to work from the United States Code of Conduct, the Code of Conduct for United States judges that applies to all U.S. judges, Article 3, magistrates, bankruptcy judges, etc. Because I think, first of all, I think it's an excellent document, and I also think it gives a fairly good encapsulation of the rules, right? So in the first line of the commentary to these United States Code of Conduct admonitions, it says, and I quote, "Deference to the judgments and rulings of courts depends on public confidence in the integrity and independence of judges." End quote. And then later it provides, a judge should, and I excerpt, act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Right? And a lot of that can be interpreted to say one brings a certain solemnity to the proceedings, but judges are humans, and some things require a greater degree of solemnity than others. And so Coming to you from the Fifth Circuit United States Court of Appeals is an opinion that provides in the reasoning section as follows. Our decision in Robbins Tire, interpreting Congress' reported desires, exposed workers to their boss's ire. The High Court, avoiding this sticky quagmire, in fearing employers would threaten to fire, sent our holding to the funeral pyre. Then along came Clemens Wire, soon after its venerable sire. To elections, Wire extended Tire, leaving appellees higher and drier. Now to colors our focused must shift, to greenwood and stores that are red. We hope this attempt at a rhyme, perhaps too, has not left this audience feeling too blue. Since Clemens Wire directly controls our decision here, we reverse. Kind of cute, kind of like the first one. And it's a commercial case. It's not the kind of thing that would be particularly offensive to the readers. After all, one expects a certain degree of sophistication from commercial litigants. And I don't think there was anything in that decision that poked particular fun at the parties or at the counsel. In fact, if the court was doing anything, it was poking fun at itself, because basically what it was obviously saying, or obviously was saying, was that the court had ruled otherwise and then gotten reversed by the U.S. Supreme Court, and that decision controlled, and hence the result today. Also from the Fifth Circuit 3 years later, now in 1982, a farmer appealed a decision of the United States Tax Court concerning his year-end expenditure claimed on his return for prepayment of fertilizer to be delivered the following year. Now, those of you in law firm management will know that sometimes there are tax advantages to be gained from prepaying expenses, and that there is a lot of complicated IRS requirements on that. And I will not attempt to go into any of the tax law on that. However, the opinion begins, citing, by the way, chapter 3 of Ecclesiastes of the Bible, Ecclesiastes, I should say, to everything there is a season and a time to every purpose under heaven, a time to be born, a time to die, a time to plant, and a time to pluck up that which is planted. And then the court ceases the biblical quote and continues. A time to purchase fertilizer and a time to take a deduction for that which is purchased. In this appeal from a tax court decision, we are asked to determine when the time for taking a fertilizer deduction should be. And then there's a recitation of the facts. And the court states, as luck would have it, the taxpayers' 1975 income tax return was selected for examination. The Internal Revenue Service took the position the $25,000 year-end expenditure could not be deducted from the taxpayer's overall income because it was merely a deposit and not a bona fide prepayment, right? So deduction disallowed. And then the opinion goes on to hold in that fashion. So again, you know, the quote from the Bible is kind of nice. Obviously, you know, the taxpayer had a personal investment in this situation. So the, you know, the sort of humor in it might have hit a little closer to home. And that goes to the temperament of the judge issuing the opinions. I don't find this personally particularly offensive. Some people might. An appellate judge that I worked for many years ago explained to those of us writing for him his own philosophy on judicial opinions. And you know, I'll refer back to the United States Code of Conduct first, right? So we talked about impartiality and an exhibit of integrity and that sort of thing. The canons continue at Canon 2A to say, an appearance of impropriety occurs when reasonable minds with knowledge of all the relevant circumstances would conclude that ellipses, temperament or fitness to serve as a judge is impaired, right? So you want to show judicial temperament. That's fairly well known. And that carries over not just into a judge's conduct on the bench, but also to the judge's opinion writing. So the appellate judge who I worked for told us that his philosophy in writing opinions was, particularly where the opinion was involving a natural person or persons as litigants, that he wanted his opinions written in a fashion where he could envision the litigants taking that appellate opinion and reading it together at the dinner table after the conclusion of their dinner and trying to understand, in all likelihood, why they'd just lost their case, right? And so he wanted the opinions written clearly, and he certainly didn't want anybody poking fun at the litigants, because that reflects badly on the courts. And it doesn't take a master's degree in government to know that for the courts to function properly and for the court's judgments to be adhered to, there has to be a respect for the courts, right? I mean, that seems pretty basic. But particularly in how an opinion is written when it affects personal litigants as opposed to a large tire company, you try to be mindful of the fact that it will be read by the affected persons, and teasing them and making fun of them is probably a no-no. One of the finest examples of the other side of the spectrum was an opinion that I read years ago. It came out of federal court sitting in Wailuku, Hawaii on Maui, and the case involved a drowning death off a hotel beach on Maui. And it will come as no surprise to many of you that trying to hold a hotel liable for something in a state that focuses on tourism is pretty darn hard. Don't try water injuries in Hawaii or Nevada or one of those places, I can tell you that. But in the beginning of the opinion that went into detail about why the state's assumption of risk doctrine, which was truly an expansive application of assumption of risk, why that doctrine was the death knell for this wrongful death suit, the judge began by beginning and stating the facts to say that he was prefacing his opinion by saying that by all accounts, the decedent was an exceedingly decent person, a family man, well regarded in his community, much loved by his family, and so on. And it went on for that for some time. And it was a particularly thoughtful thing, I think, in judicial opinion writing, because it acknowledged the humanity of the person who was lost and of the obvious loss to the family, including what was probably a not at all insignificant loss of future earnings. And the judge took the time to do that before he delivered the coup de grace to their wrongful death action, seeking recovery for the water injury, the drowning death. And so that was sort of an example of the kind of thing that one really likes to see in an opinion. Now, here's a little bit of jocularity, and it did poke some fun at the people involved. But in this case, it sounds like it was fairly richly deserved. We'll go back to the Fifth Circuit, a source of great material for us today, 4 years later. And here they are again. And by the way, these were different judges who wrote each of these Fifth Circuit opinions. The case concerned cotton subsidies to cotton farmers during the 1970s. And this was a criminal case. And the case alleged improperly obtained overpayments through a scheme or device to defeat the purpose of what was called the Upland Cotton Price Support Program, and specifically to evade that program's payment limitations. And the court said, and you can tell how it feels about this, and I quote, "The scam involved millions of dollars," end quote. Well, the fact, if you're reading this and you're one of the litigants, the fact that it's referred to as a scam in the second paragraph of the opinion should be a tip-off as to how it comes out. But anyway, the circuit judge began the opinion with the following, and I quote, "Some farmers from Gaines had a plan. It amounted to quite a big scam. But the payments for cotton began to smell rotten. 'Twas a mugging of poor Uncle Sam. The ASCS and its crew uncovered this fraudulent stew. After quite a few hearings, the end is now nearing. It awaits our judicial review." And from the repeated use of scam, you can kind of tell how that comes out. So I'm sure the individual cotton farmers at issue there did not enjoy the jocularity, but the court seemed to be offended by their conduct. And so, there you have it. We now go to U.S. District Court in West Palm Beach, Florida. This is a case involving a fire on a boat that threw chunks of debris at other expensive yachts. Keep in mind, this is coming to you from Palm Beach, so you'll be shocked to know that there were yachts and there was subsequently litigation. And during the course of the pretrial proceedings, plaintiff amended her complaint to add a new party, and then that new party removed the matter to federal court, claiming original jurisdiction, and asserted the removal was timely because it followed an amended complaint. And the argument is that the admiralty laws provided a federal claim. In a section concerning the timeliness of removal, the court titled the section "A Swing and a Miss," and said the removal was untimely, and said, and I quote, "As a result, Prime Time's removal almost 10 months after commencement of suit is untimely and is a defect deemed way improvident. For similar reasons, the court finds that removal of the Noble case, which had been remanded, was also untimely." And, this is following the point heading that says "a swing and a miss." You get a feeling that the court had been watching the Mike Myers movie of the time. And so the court continues, "In short, Prime Time's most bogus attempt at removal is not worthy, and the defendants must party on in state court." Okay, kind of cute, but not particularly offensive, because I think it was directed more at the lawyers who thought they had timely removal and not at the parties themselves. Okie dokie. As long as we're in Florida, we'll take a quick jaunt around the same time over to the bankruptcy court, Southern District of Florida. The court tells us, "This cause came on to be heard sua sponte upon the court's own motion to dismiss this Chapter 7 petition. And the court received the inspiration for the motion from a little old ebony bird, and not from any party in interest or any other person. And having considered the presumption in favor of the debtor provided in the Bankruptcy Code and not deeming it appropriate to take evidence, the court finds." And sit back. "Once upon a midnight dreary, as I pondered weak and weary over many quaint and curious files of Chapter 7 lore, while I nodded, nearly napping, suddenly there came a tapping, as of someone gently rapping at my chamber door. 'Tis some debtor," I muttered, tapping at my chamber door, "only this and nothing more. Distinctly I recall it was in the early fall, and the file still was small. The code provided I could use it if someone tried to substantially abuse it. No party asked that it be heard. Sua sponte," whispered a small black bird. The bird itself, my only maven, strongly looked to be a raven. Upon the words the bird had uttered, I gazed at all the files cluttered. Sua sponte, I recall, had no meaning, none at all. And the cluttered files sprawl drove a thought into my brain. Eagerly I wished the morrow, vainly I had sought to borrow from Bafcha surcease of all sorrow, and an order quick and plain that this case would not remain as a source of further pain. The procedure, it seemed plain, as the case Grew older, I perceived I must be bolder, and must sua sponte act to determine every fact. If primarily consumer debts are faced, perhaps this case is wrongly placed. This is a thought that I must face, perhaps. I should dismiss this case. I moved sua sponte to dismiss it, for I knew I would not miss it. The code said I could, I knew it, but not exactly how to do it, or perhaps someday I'd rue it. I leaped up and struck my gavel for the mystery to unravel. Could I, sua sponte, grant my motion to dismiss? While it seemed the thing to do, suddenly I thought of this, looking towards the future and to what there was to see. If my motion, it was granted, and an appeal there came to be, who would be the appellee? Surely it would not be me. Who would file, but pray tell me, a learned brief for the appellee? The district judge would not do so. At least this much I do know. Tell me, Raven, how to go. As I with the ruling wrestled, in the statute I saw nestled a presumption with a flavor clearly in the debtor's favor. No evidence had I taken, sua sponte, appeared forsaken. Now my motion caused me terror. A dismissal would be error. In consideration of the code, in anguish loud I cried, the court's sua sponte to dismiss is denied. It's pretty funny stuff. So the court had said on its own motion it considered dismissing the case, but then realized it was procedurally improper to do so, yet wrote this anyway. Well, why? It was clearly a message to the United States trustee to make a motion, and then there would be a party, and it would be granted, and the Chapter 7 would be dismissed. So, you know, pretty funny stuff. The judge was enjoying himself, and it didn't poke fun at the litigants or really anybody. I mean, it's plain that the court was of the view the bankruptcy petition was not properly taken, but not so bad. Indianapolis for a boating accident, who knew? Scuba diving in Indianapolis, I will leave to the audience. Scuba diver was injured when a huge wave, court's words, struck a dive boat and injured one of the divers. This was going to the dive site, and the diver's case alleged that the boat driver should have waited until the huge wave passed before piloting into the channel, all right? And so the court found that the Cayman Islands, this must have been where it occurred, I see, they sued when they got home. The Cayman Islands laws were applicable as to the validity and scope of the release form, and since there was no Cayman law on point, English common laws would apply, as Cayman Islands are a British territory. This makes sense. And then the court concluded that scope of the release was limited to injuries relating to scuba dive and was inapplicable to injuries on the boat. That's an interesting one when you think about it. So you sign a release, you know, an assumption of release of liability, kind of a contractual assumption of risk for injuries on a scuba dive in the Cayman Islands. You get injured while you're on the boat. And the court said the release only applies when you're in the water, not on the boat. I don't know about that. I mean, I leave it to the audience, but I could easily see that one coming out the other way. So in the opinion, it begins, just sit right back and you'll hear a tale of what happened when this gentleman went scuba diving, and then there's a footnote that has the quote from the Gilligan's Island song. And the court continues in its statement of facts to say, and I quote, "The dive boat started its short trip to the dive site, but as it entered a channel in the barrier reef that surrounds Little Cayman, the weather started getting rough, and the tiny ship was tossed, although ultimately the boat neither would be lost nor stranded on the shore of an uncharted desert isle. The plaintiff was injured, filed this action claiming the skipper of the dive boat should have waited until the wave passed, that perhaps the skipper was too brave and sure." Kind of fun, a bit of Gilligan's Island stuff in there. Show was off the air by 1992. Some jocularity, kind of harmless. Here we've got an individual involved, but hey, look, he won. How annoyed or disheartened could he be? So, you know, again, referring back to our judicial canons, right? I mean, jocularity fine, and no individuals are harmed, as they say in the commercials that show animals, right? So we're probably in okay shape. But I'll just go back to another provision of the canons I hadn't read, and it says a judge should be patient, dignified, respectful, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the court deals in an official capacity, end quote. All right. Patient, dignified, respectful, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the court deals. All righty, okay. Federal Court, Missouri, Southeastern Division, 1984. The government sought an action to forfeit a pickup truck that had been used in the connection of raising marijuana. You've seen these forfeiture actions before. If you check your filing reports, they'll say something like United States versus 1989 Cadillac Eldorado, or versus $1,200,000 in cash, or what have you, or they'll actually say United States currency. And those are forfeiture actions. And so then the court continues in this forfeiture case. Now, you remember what I was mentioning earlier about how you really don't want to, as a judge, you don't want to really pick too heavily on an individual litigant. But here, I suppose one could take the view the litigant was a pot farmer. And given the amount of pot involved and the laws at the time, presumably he could afford a new truck. And so the court wrote in its findings of fact as follows. The defendant herein is a truck. The vehicle type is a pickup, alleged by a Fed to be found in a bed of marijuana caught in the muck. On August 1682, in Perry County, Missouri, who should appear but claimant Hudson with gear as a one-man pot-tending crew. Claimant drove defendant that day with tools to care for his illegal hay. He was observed by a Fed placing metal in a shed where other tools of his trade lay. The claimant's arrest was then made. 'Tis illegal after all his trade, and defendant was seized with comparative ease by the government with which it has stayed. Claimant now wants his truck back and bases his legal attack on the grounds that defendant, though found in pot fields resplendent, was not used as an illegal hack. While it's true that not one plant or seed could be found on defendant indeed, claimants argue as tissue for the dispositive issue. Did the defendant facilitate the deed? In the U.S. v. 1 Cadillac, the Second Circuit addressed this attack, and those judges renowned eventually found claimant's assertion misread law and fact. They gave facilitate a wide definition, these jurists of great erudition. They found the seizure was proper, and now here's the heart stopper. If the truck in any manner facilitates the illegal condition, in Cadillac as in the case at bar, defendant just transported men near and far, but this was sufficient to make claimant's trade more efficient, and therefore justified seizing the car. Thus the Cadillac case this court will follow renders claimant's contention hard to swallow, and the court will now render judgment against the defender, because claimant's contentions are hollow. Now the moral in this case about the truck is easy in case you are stuck. If in an illegal endeavor a vehicle is used whatsoever, then my friend, you are clear out of luck, end quote. Well, it's kind of neat, because unlike the first one we put in there, the court applied precedent, cited the precedent from the Superior Court of Appeals, explained its reasoning, applied facts to law. Hey, not bad, doing all that in rhyme. We've seen a lot worse. Now, the U.S. District Court from the Eastern District of Pennsylvania. It had quite a back and forth here, and this again, interestingly enough, was another, as people say, a ship case, and this one dealt with personal jurisdiction. The question being whether suit was proper in Pennsylvania on a New York ship, right? And the court provides. The motion now here has stirred up a terrible fuss, and what is considerably worse, it has spawned some preposterous doggerel verse. The plaintiff, a man of the sea, after paying his lawyer a fee, filed a complaint of several pages to recover statutory wages. The pleaded facts remind us of a tale that is endless. A seaman whom for centuries the law has called friendless is discharged from his ship before voyage's end and sues for lost wages, his finances to mend. The defendant shipping company's office is based in New York, and to get right down to the nitty-gritty, it has been brought to this court by long-armed service, which made it extremely nervous. Founded upon a doing business rule, but defendant has no office here and says it has no mania to do any business in Pennsylvania. Plaintiff found defendant had a ship here in June 72, but defendant says that ship's business is through. Asserting that process is amiss, it has filed a motion to dismiss. The plaintiff's counsel, whose name is Henry Lohr, read defendant's brief and found it a bore. Instead of a reply brief, he acted pretty quick and responded with a clever limerick. See, here it becomes interesting, because what started this whole rhyming in this opinion was the motion to dismiss filed by the New York company, who is now quoted in the opinion. Admiralty process is a hoary with pleadings that tell a sad story of libels and rem, the bane of seafaring men. The moral, be personally served, then be sorry. All right, well, the defendant couldn't resist and responded as follows, also quoted. The court says, not to be outdone, the defense took the time to reply with their own clever rhyme, drafting a poem that cut right to the pith. And the court quotes, Admiralty lawyers like Harry, both current and those known from lore, must learn to sidestep our bore, for Smith, not known for his worth, with his knife out for Mackensworth, with writs, papers, or motions to quash, knows dearly that dear Harry's positions don't wash. Overwhelmed by this, now the court goes on, overwhelmed by this outburst of pure creativity, we determined to show an equal proclivity. Hence this opinion in a form of verse, even if not the caliber of St. Jean Perse. The first question is whether under the facts, defendant has done business here under Pennsylvania's long-arm acts. Defendant runs a ship known as the SS Washington Trader, whose travels plaintiff tracked, as GM is said to have followed Nader. Searching for a rhyme there, clearly. He found that in June 72, the ship rested its keel and took on a load of cargo here, which was quite a big deal. In order for extraterritorial jurisdiction to obtain, it is enough that defendant do a single act in PA for pecuniary gain. And we hold that the recent visit of defendant's ship to Philadelphia's port is doing business enough to bring it before this court. Well, that's kind of cute. You know, one of the lawyers started it. You sort of get the feeling in that case, admiralty law is, as you may know, a very specialized field, and Philadelphia does have quite a large and active seaport. But even in very large and active seaports like those we have here in Port of Los Angeles and Port of Long Beach, the admiralty bar is small. And one is sort of taken to the conclusion that they all know each other, and so it's not entirely out of mind that everybody decided to have a little fun with this. I'll turn to something just a little bit more, perhaps serious by way of contrast. This comes to us from California, and I do not say this with particular pride, from the Second District Court of Appeal, which is primarily based in the Los Angeles County area. And this was a case about, this was a criminal case involving a couple of people for possession of obscene films with intent to distribute. Now, none of the facts here are particularly relevant. What is relevant is the brouhaha that occurred between the justices on this court. There was a majority opinion. There was a very strong dissent. And for those of you who don't know the procedures in the California Courts of Appeal, motions will be circulated. A justice may object to the motion or may have already drafted one of their own. And usually the dissenting justice, will obviously see the draft of the majority opinion. The writers of the majority will see the dissent. People may make some changes and edits. That's sort of contemplated, and that's all in the ordinary course. I suppose the concept being that allowing the judges to debate amongst themselves is exactly the reason why you'd have a three-justice court. Let me go back to, before I give you the further specifics, the canons of conduct for United States judges. Now, these were not United States judges, they were state court judges, but again, these federal canons, I think, are generally expositive of what is expected. And I shall repeat: a judge should be patient, dignified, respectful, and courteous to the litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. Sounds pretty cool, right? Here is a footnote from the dissent. I'm going to read you the dissent's footnote first. This was obviously added after the majority had added a footnote of its own, and now the dissenting judge comes back, and in the interim, somebody caught wind of this, I don't know who, I didn't research it, and brought the majority's footnote to the attention of the Los Angeles Times about a week later. Right? So this, in all likelihood, was modified after issuance. You can do that in California Courts of Appeal. You can modify your decision even after it's been published. Here is the footnote from the dissent, and I quote, "I have heretofore eschewed responding to footnote 2 in the majority opinion in kind, since it would be beneath the dignity of this office. Although I still will not respond in kind, with the filing of a modification," see, I was right, "with the filing of a modification, some comment is compelled. I decry the lack of propriety, collegiality, and judicial temperament displayed in footnote 2. I abhor the loss of public respect for the legal profession and the judiciary footnote 2 has engendered by reason of the report in the Los Angeles Times on March 13, 1979, circulation 1,034,329. The footnote 2, to which the dissenting judge takes such great offense in the Los Angeles Times, apparently took such interest, reads as follows: "We feel compelled by the dissenting opinion to spell out a response. 1. Some answer is required to the dissent's charge. 2. Certainly we do not endorse victimless crime. 3. How that question is involved escapes us. 4. Moreover, the constitutional issue is significant. 5. Ultimately, it must be addressed in light of clear precedent. 6. Certainly the course of precedent is clear. 7. Knowing that, our result is compelled." Sounds good, right? Here's the problem. If you read down those 7 points carefully listed in a column in the footnote, if you read the first letter of each of them, they spell out the word schmuck, obviously directed at another member of the court, namely the author of the dissenting opinion. I'll leave it to you to look up the Yiddish meaning. But that, I think, was probably a pretty clear violation of at least the concepts of what the ethics of judicial propriety would encourage. That was just a mean-spirited attack. I will tell you, there are some courts where some of the justices have really disliked each other, and boy, does it come through in that sort of thing. And I haven't seen anything like that, frankly, in my own experience. I've seen some fun in judicial footnotes. I've known people who've written some fun things in judicial footnotes. But that's really kind of over the top. For something a little lighter, we'll go to the Southern District of New York, referred to as the Mother Court, the original United States District Court. Very, very highly regarded over the years, tackles complex area of law, based at 500 Pearl Street in Manhattan, but with other branches in Long Island, and in this case in White Plains. And this is a copyright case, and as you can tell, copyright basically hinges on the protection of things that are subject to copyright. In this case, cartoon characters. And so I'll just read you the first couple paragraphs of the opinion. Once upon a time in lands far, far away lived strange but cuddly creatures that became involved in a struggle for identity. In Whatland, which is just a few miles north of Fairyland, lived the Whats. In the land of Was lived the Wuzzles. We don't know where Was, but we are told we could get there if we snuzzle a wuzzle. It appears that for a time never did the two meet. But one day the creators of the Whats discovered the Wuzzles and were astonished to learn that the Whats and Wuzzles had certain similarities. Most specifically, it seems each What and each Wuzzle had the names and characteristics of two different animals combined into one. In Whatland there was a meows, mouse and a cat, a wish, a walrus and a seal, a chuck, chicken and a duck, skeet, skunk and a parakeet, peter, peacock and a turkey, gurich, giraffe and ostrich, leolamo, I'm going to spare you a bit of this. The Wuzzles included moosel, a moose and a seal, butterbear, a butterfly and a bear, hoppopotamus, rabbit and a hippopotamus, elaroo, elephant and kangaroo, rhinoki, these are probably better than the original, rhinoki, a rhinoceros and monkey, and bumblelion, a bumblebee and a lion. And then the court goes on. Our story now moves to its sad conclusion. The creators of the Whats, who were protected by copyright, were outraged and thought that the creators of the Wuzzles had stolen their idea. A lawsuit broke out with plaintiffs, the creator of the Whats, alleging violation of the federal copyright law. The defendants, creators of the Wuzzles, have moved for summary judgment as well as attorney's fees and sanctions under the Copyright Act for plaintiffs' pursuit of frivolous and vexatious litigation. This battle on high between creators is filtered down to us in this whatless and wuzzleless land of White Plains. The questions before us are really quite simple. Just what's a what? What's the similarity between a what and a wuzzle? And wuzzle do we do about it? Anyway, lots of joking there. Owners of the copyright obviously cared. You get the feeling that the owners of the copyright clearly won. And the judge had a little bit of fun with the whole thing, probably because the case wasn't even a close call. Here's an interesting one. So again, let's focus back on the point here. The point here is that a court has to conduct itself in a way that engenders respect, right? The rule of law, you got to keep in mind, the only reason the rule of law works is because it's consensual, right? As a society as a whole, we consent to be governed by the laws under which we operate. And when respect for the courts is lost, the rule of law crumbles, and the rule of law suffers vicious cuts and bruises when it is attacked as not being competent, or when it's attacked as being, frankly, political, right? When its independence and impartiality is attacked. The rule of law is a much more fragile thing than a lot of people would have it to be. And I've found in my own personal experience that judges are actually quite protective of the rule of law, probably knowing just how delicate a creature it is. However, that said, there are some instances where things are kind of clear. And again, judges being humans, you may as well have a little fun with it, I suppose, if that's your proclivity. Although I'll say one thing, and it goes back to that California opinion, and I think it's particularly important. Boy, how mean-spirited to call one of your colleagues on the bench a schmuck. I mean, it brings dishonor to everybody involved. Not to the poor guy who was called it. A schmuck he might be, but really calling him that, not called for in my view. In any event, this case from federal court in Pennsylvania, Eastern District, so Philadelphia, this comes to us on a criminal matter with what was apparently independent, appointed defense counsel, right, public defense counsel, and they have an obligation to review the case and see whether there's a basis a basis for any kind of appeal or rehearing or reconsideration. And so this one did just that, and then filed a paper with the court, which is recounted in the appendix to the judge's order. And I'll begin with that. It's addressed to the judge from this counsel and dated, and it says, and I quote, "I have reviewed the rules, I have examined the notes, I have read the cases, I have gone through the law, I have given it my all. The following is what I have to say. To the Honorable Gothrop, my objections were 4. I hope there would be more. You, super smart fox, you stopped me in my socks. My errors 4 I bury beneath the floor. My positions I surrender to the decision you must render. Errors were not many, and they were not worth a penny. To object was right, but all for naught. The decisions can't be fought. The record seems sound, so to jail my man will be bound. I should like to have persevered, but there is no point. Off he goes to the joint." Well, you know, you have an obligation. You have an obligation to zealous advocacy, obviously, for your client. You have an obligation to present any colorable arguments. But you also have an obligation not to present spurious arguments, right? Particularly ones that are totally unsupported by the law. And that's apparently what the author of that memorandum to the judge, who apparently had tried the case, had concluded. He'd made his trial objections. You often have to make your trial objections without ample time to reflect upon the law. The judge had ruled upon those objections unfavorably to him, and then when he got an opportunity to research and reflect, he concluded that there was no appellate basis in those objections. And the court appreciated it. And so, you know, attaching that communication, the court issued an order reading as follows. "And now to wit this April day, counsel having had his say, Anders, California would seem to say, new trial, no way. Forthright counsel I commend for bringing this appeal to end. He has served his client well, a worthless issue would not sell. Dropping his quixotic quest serves his client's interests best. To press a cause of rank frivolity would not fill this court with jollity. Though counsel was a courtroom terror, he could not see the case with error. So nothing now could be much grander than witnessing his post-trial candor. Lawyers tend to look facetious, pressing issues merely specious. Frank candor sure beats false bravado, defending Claudio Rosado. This is how I see the moral, instead of never-ending quarrel, a broken record crying foul, it's sometimes best to throw the towel. Thus before the bar of court this defendant must report. He shall have to do his time, for punishment must fit the crime, and that will have to end this rhyme." Not bad, not bad. And, you know, yes, it was a criminal case. I will say judges are a lot more reticent to joke around in criminal matters, and they should be. But in this particular one, if there really wasn't any error to be found, it was sort of right on them to fall on their sword. And so I offer that to you. We will go now back to Florida. Back to Florida, State Court of Appeal. This was a case about a number of defendants acting in a prison escape. And the question was whether intent to avoid confinement was an essential element of the act of committing a prison escape, whatever the proper term for that might be in Florida at the time. And the reason, and one, by the way, would assume yes, right? I mean, if you take a sleeping fella and drag him out of his cell without his knowledge or what have you, it kind of makes you wonder. But this case was kind of interesting because the question hinged on whether intent was an element. A defense that was provided was the particular defendant, they must not have been tried together, this particular defendant had become intoxicated on Christmas Eve by liquor supplied, of course. Well, I'll let the judge tell the story. And then, you know, intoxication of defense to intent. Sure, the court was less than convinced because, yes, the guy might have been intoxicated and not intended to escape as a result of that intoxication. But once he was escaped, he found he liked it, and he stayed outside and hiding for about a month. And the court inferred intent from that. And I'll leave it to the experts to say whether that's proper, right? All right, so the court says at trial, the trial judge refused to allow the defense to introduce evidence of intoxication on the ground that intent is not an element of the crime charged. The proffered evidence showed that the jailer at the detention center gave vodka to the inmates on the night of the escape. The effect of the inebriating beverage on the appellant and his fellow inmates was colorfully portrayed by defense counsel in closing argument to the jury as follows. Hang a footnote here. I am truly not sure I would have been brave enough to present this rhyme in closing argument in a case of, you know, fairly serious criminal charge, and I don't think I would have done it myself, but it was done, and so here it is. Closing argument. This is not the court speaking. Closing argument. It was the night before Christmas when all through the jail not an inmate was stirring. They couldn't make bail. The stockings were hung by the cell door with care in hopes that St. Nicholas would soon be there. The inmates were huddled alone in their beds with visions of freedom danced in their heads. And guards in their uniforms and John and his rack had just settled down for a long winter's nap. When up on the roof there arose such a clatter, John sprang from his bed to see what was the matter. Away to the window he flew like a flash, tore open the cell door and threw up the sash, when what to his wondering eyes should appear but a miniature sleigh and 8 tiny reindeer. With a little old driver so lively and quick, he knew in a moment it must be St. Nick. More rapid than eagles his courses they came, and he whistled and shouted and called them by names. Now McGuire, now Bass, now Fillingame, Newman, on Ingram, on Suggs, on Crosby and Helton, to the top of the porch, to the top of the wall. Now dash away, all. I don't know. I'm going to leave this to your judgment. Everybody can have their own opinion, and there's no right or wrong on this. I don't know. Go back to the canons. A judge should be patient, dignified, respectful, and courteous to litigants and others with whom the judge deals. So this is a criminal case. You know, this is probably a pretty substantial enhancement here for a prison break. You can imagine it probably carried quite a stiff additional term, particularly in Florida in the 1970s. And you know, I'll leave it to your collective wisdom whether this was on the wrong side of the ethical rules for judicial temperament here. You know, I tend to have my own opinion, but that's no better, that carries no more weight than your own. But I offer that to you in light of this example that I gave you from the canons. Now we have a fun one from Georgia, and this is a short one, and I don't think this really gores anybody's ox myself. This is a case where in a civil action, I might matter, I think that makes a difference. In a civil action, after a trial, defendant claimed that a juror should have been disqualified because the juror's wife was first cousin to the plaintiff's wife. But the defendant, now claiming error on appeal, did not reveal that the wife of such juror was also a second cousin to defendant's wife. Foul, foul play, the defendant cried. 'Tis I by kinsman not be trammeled, lest the issue again be tried before another jury impaneled. Remember how from John at Runnymede the charter was forced and wrested, that no matter what the issue or deed, by my peers it must be tried and tested. Anyway, it goes on, but the court continues on to say, no foul play do I find or see, the judge replied, foreman's wife to thine, and to kinsman's wife, and to plaintiff's wife may kinsman be, but to Duggan thee no kinship do I find. Moreover, when kinships we sought to learn, it does not appear that as best befits one who would a kinsman spurn, thou revealed that cousin did on panel sit. Thy day in court thou hast had, the judge asserted, and the law commands that no error, whether good or bad, the issue tried and settled stands. Well, kind of cute, and you know, you can sort of see why the judge did that. It seemed like it was being claimed. You know, you claim disqualification grounds when it's against you, but not disclose it when it favors you. So again, keeping in mind our theme of, you know, the sort of appearance of judicial impartiality and also really the underlying current of having respect for the litigants. And again, I'll harken back for it, patient, dignified, respectful, and courteous to litigants, right? And I'm trying to stress that some of this is situational, right? It depends on the facts. It depends on who the parties are. There are certain kinds of cases that are, you know, really particularly emotionally laden, and where one would think that a judge would be kind of careful in how he or she expressed themselves in dealing with them. And I think divorce cases are one of those. And this is a case that comes out of Ohio. It's a relatively modern case, 1993. I know there are people watching who were 10 in 1993, and I apologize. But for those of us who were not, you know, I think it's a relatively modern case. And this was a case by a bride-to-be against a groom-to-be. She alleged claim for emotional distress for breaking off the engagement. Under the laws of many jurisdictions, these are so-called amatory actions, and you can't sue somebody for not marrying you. The concept is public policy. No matter how badly, you know, somebody was treated by their engaged or betrothed counterparty, the law is not going to impose civil liability and force them to marry because that, you know, or suggest to them that they need to marry at the risk of civil liability, because that is not what we want to encourage, and it usually leads to worse. Well, in any event, in my opinion, this opinion sets forth the facts, but in a way that, you know, I certainly wouldn't want one of my relatives written about in this fashion. And I'll excerpt some of it, right? But I'll quote, and I'll hold up my hand or something when I excerpt. Plaintiff Doris Irvin, by and through her complaint, alleges that one Jimmy Smith, apparently not quite a saint, wooed her from her calling, missionary for her church, promised her the aisle, then left her in the lurch. Our story starts at a plaza, Arlington to be precise, where by chance the within parties met, and Jimmy began his artifice. Not a good poem. Doris disdained conversation with married and unknown men. Jimmy decried his marital status and suggested they meet again. Doris, intrigued and enchanted, agreed to Jimmy's invite. The two met for dinner the next evening, and so began a most memorable night. Jimmy asked Doris to marry as soon as his divorce was complete. Doris replied with yeses and prepared for the marital feat. Now Jimmy, imbued with the season, bought Doris on St. Valentine's Day candies and gifts and good wishes, and amore to give and to say. In June on the 7th, he came to her home, and he mentioned to Doris' daughter dear that he intended to marry her mother, always to draw her near. And then it goes on from there, and it talks about Doris's plans for her wedding and so on and so forth. And then it says, on the 13th of August, at Jimmy's request, Doris went to his East Akron dome. He informed her the betrothal was off, as his estranged wife would soon be coming home. He offered condolence and counseling due to Doris' enraged state of mind, and he said that he needed a wife at his home, not a street woman, being rather unkind. Doris says that Jimmy related his wife was away, not estranged, that she spent a few months in Alabama on a vacation that had been prearranged, and that Jimmy, on August the 14th, alleging threats and harassment, reported Doris to Akron police, attempting to cause her embarrassment. Doris says her former beau's blandishment has hurt her in numerous ways, that his intention of emotional distress has sent her into an emotional daze. She has markedly increased hypertension and suffered the loss of some weight. Her appetite seems to be somewhere else, and her embarrassment will not abate. Doris says that Jimmy's enticements lured her into his board and his bed, that his promise of nuptial happiness made her act from her heart, not her head. Doris says this Jim should be punished for using and abusing her trust, and asks in her prayer as advanced to the court for $50,000 or whatever is just. Now, Jimmy has moved for dismissal, saying Doris hasn't stated a claim. He believes Doris should take nothing, with nothing besmirching his name. Jimmy plaintively asks that the court, in reviewing the matter herein, consider the state of the evidence, then promptly do Doris' case in. In order to grant a dismissal, the court must accept as true the factual allegations in the complaint and all inferences made thereto, and so on and so forth. And then the court says it's an amatory action and it's dismissed. Well, you know, this was a decision on a motion to dismiss. Plainly, the court does indeed, as it acknowledged, have to take the facts as true. You know, and the court recites the facts in this rather poorly written poem, and no evidence was taken here, so assuming the facts are true, this woman was in a pretty terrible condition as a result of this very unfortunate situation. And so to place it in rhyme, I'm not even going to bother to express my own views. You can guess what they are. I leave them to you. Back to the canons, a judge should be patient, dignified, respectful, and courteous to the litigants. Well, again, I'm going to leave it to you. Here's another, just in closing, nuptial case, and this involves a concurring opinion, and this comes to us, poor Pennsylvania. Pennsylvania is a nice commonwealth in most ways. I'm not going to bother to tell you the facts. You'll get them from this concurring opinion. A groom must expect matrimonial pandemonium when his spouse finds he's given her zirconium instead of a diamond in her engagement band. The one he said was worth 21 grand. Our deceiver would claim that when his bride relied on a gift of such value, she was not justified, for she should have appraised it, and surely she could have. But the question is whether a bride-to-be would have. The realities of the parties control the equation, and here they're not comparable in sophistication. The reasonableness of her reliance we just cannot gauge with a yardstick of equal experience and age. This must be remembered when applying the test by which the responsible fiancé is assessed. She was 19, he was nearly 30 years older. Was it unreasonable for her to believe what he told her? You know, I guess it makes sense to me, but again, even though the fiancé wins here, rhyme, I'm not so sure. Well, here's a concurring opinion from the Chief Justice. And by the way, this is the highest court in Pennsylvania. I didn't mention it, the Supreme Court. So here's the Chief Justice, and you know what, I'll do it. I say good on him. And I'm going to close with this quote from the Chief Justice, and I offer it to you for whatever you take it to be worth. And I quote, "I join Justice Newman's opinion. I write separately to express my grave concern that the filing of an opinion that expresses itself in rhyme reflects poorly on the Supreme Court of Pennsylvania. While one may disagree intellectually with another's judicial philosophy, and the exchange of differing views is at the very core of a jurist's function, it is the substance of our views that should be the focus of discussion. The gravity of differing judicial views is diminished when the focus is taken away from their substance because of the form in which they are presented." And with that, I close, and I do thank you all for your time.